The DA's case is about who decides whether to increase the VAT rate and ensuring that that entity, Parliament, does so lawfully. The VAT increase may be a good idea or a bad idea, but VAT can only be increased when Parliament does it after following a lawful process. That is our case. So much of the argument from the Minister and Parliament about polycentricity and balancing different concerns and raising the VAT, that's largely irrelevant to our case, because our case is just about making sure that the democratically elected representatives of South Africans decide that polycentric issue, and not the Minister, and that Parliament does so after a lawful process, where they make a clear decision. The second remark is that there's a theme in the Minister's case, which is that only the National Treasury and the Minister can be trusted to make fiscal decisions. It comes through various places in the affidavit and the heads. I'll give the court one example. This is from paragraph 12.2 of the Minister's case. It says, when the Minister announces an adjustment to the VAT rate as part of the annual budget, that decision is the product of this comprehensive process and benefits from National Treasury's expert judgment on how best to ensure fiscal stability and meet the country's funding needs. And there's our fundamental case, particularly with regard to Section 7.4 of the VAT Act, is that that's not a decision for the Minister or National Treasury to make. It is a decision for Parliament to make. And much of the face of the Minister's announcement rests on this flawed premise that the role of the National Treasury and the Minister is to determine the funding needs and ensure fiscal stability. They have a role there, but they have a proposing role. The decision-making role is always with Parliament, on both how much revenue to raise, how to raise it, and how to spend it. The third remark I want to make is about the structure of the DA's case. And this is important because our case is slightly different from the EFF's case. So we have two separate causes of action, but there is a connection between the two. The first cause of action is a request for interim relief to suspend the operation of the VAT House. And the reason the substantive cause of action is because Section 7.4, the source of the power, is unconstitutional. So we want to suspend it pending the outcome of the challenge to Section 7.4. The second part of our case is an attack on Parliament's decision to adopt the fiscal framework. And we said that the reasons for that are because it was unlawful, because there was no clear statement, and what was in the report before Parliament was not what was decided by the Commission. So those are two separate causes of action. But there is a link. The link is this. When this court is considering whether to exercise its just and equitable power to suspend the Minister's decision, and I'll get to the nature of that power, but we submit the court has the power, if it's just and equitable, to suspend that decision. One of the factors it will consider is that Parliament has not lawfully endorsed the VAT increase. In fact, if one looks at it, and I will get to these facts, Parliament has unanimously rejected an unconditional VAT increase. The NKP, the DA, the EFF all voted against any VAT increase. And those who supported it supported a conditional VAT increase. And moreover, if one looks at the fact, it's very unlikely that Parliament will, in the future, adopt the VAT increase in legislation. And we set out the facts for that. I'll take the court to them. But that's the connection between the two parts of our case. The fourth framing remark is about the DA's motivation. There's a lot in the answering affidavits about how the DA has a political motivation, how the DA is coming here because it lost a battle that it lost in Parliament, so trying to win in the courts, these types of arguments. But I want to deal with them up front.
Yes, isn't there some merit in it?
No, Lord.
Oh.
I submit that there isn't, for four reasons. The first is that nobody has challenged the DA's standing. The DA asserts its standing and it asserts it acts in the public interest. That's at page 02-12, paragraph 24. So the DA has standing, and has standing in terms of section 38E of the Constitution to be here in the public interest, in its own interest, and the interest of its members. The second is that the Constitutional Court has held that the motive of a litigant in a constitutional challenge is irrelevant. It's held that expressly. And the authority for that is the Fuel Retailers Association of South Africa, 2007, volume 6, SA Law Reports, page 4, and it's paragraph 101. And this is what Justice Mpofu-Walsh, as he then was, said. So the case was an environmental challenge, and conveniently the Fuel Owners Association had challenged to, perhaps not those most likely to be acting in favor of the environment, had challenged the decision on the basis that it didn't sufficiently protect the environment. And the counter-argument was, well, you should look at them very skeptically because their real motive is a commercial motive, not a motive to protect the environment. And what the court said is, if upon a proper application of the legal principles, the objections are valid, the court has no option but to uphold the objections. That is the duty that is imposed on the court by the Constitution, which is to uphold the Constitution and the law, which they must apply impartially and without fear, favor, or prejudice. Neither the identity of the litigant who raises the objection nor the motive is relevant. This is an objective question. Whether this court should suspend the operation of the minister's announcement, whether Parliament acted unlawfully or not, is an objective question. It cannot depend on who the litigants before this court may be. If this court says we're going to reach one outcome because the DA
But
is
Mr. Bishop, surely if the DA has won the vote in Parliament, would we have been here today?
I'm glad you raised that. I don't know. I don't know. We might still be here on the first part of the case. It's difficult to know what would have happened.
Can I follow that up, Mr. Bishop?
Yes.
If Parliament had voted to reject the fiscal framework and it did not adopt the report of the committee, would that in any event have any effect on the announcement and the carrying out or the coming into effect of the VAT increase on the 1st of May?
It would have no legal effect.
It will have no legal.
It would have no legal effect.
So assuming that Parliament did not adopt and everyone rejected the report, the 1st of May will still continue.
That's correct. That's how Section 74 operates. It may have been, and this is why I said maybe, that's a pronounced situation. But if that had happened, politically, the minister would then have been forced to withdraw the announcement. But as a matter of, and we wouldn't have been there. But as a matter of law, if later the minister withdrew the announcement, it will still come into effect.
So what is the effect of setting aside the decision or the resolution of Parliament, of the NCOP and the NA, and remitting the framework back to the committees if the 1st of May would continue anyway? And maybe coupled with that, whilst you're answering that question, the question is, what is the point of the elaborate process of having that is provided for, the process provided for in the PFMA, the Money Bills Act regarding the tabling of the annual budget and the fiscal framework, and it being adopted if at the end of the day the 1st of May continues anyway?
I think that's a very good question. That's one of the reasons we say Section 74 is unconstitutional. Because even after Parliament expresses in the fiscal framework that it rejects that increase, it will come into effect nonetheless. But to answer your question, that's why we've challenged both. The effect of setting aside Parliament's decision on the fiscal framework will be to restart the budget process. So it will then not have adopted the fiscal framework. It will have to go back, debate the fiscal framework, and adopt lawfully a new fiscal framework. And after that, the process in the Money Bills Act will follow. The Revision of Revenue Act, the Appropriations Act, and so on. So that's the effect of that part of our case. But I understand this is not the EFF's position, but it's our position that will not stop the VAT increase. That's why we've asked for the other part of the review, which is to suspend the announcement. And the reason we asked for the suspension of the announcement is because the power given to the minister is an unconstitutional power.
I'm still not clear then, what is the point of the elaborate process that the legislation provides for the tabling of the annual budget that includes the fiscal framework, and in this instance, that includes the proposal for the VAT increase? What's the point of all of that if the parliamentary process has absolutely no effect on the announcement by the minister?
I think the problem, lady, is that there's a disconnect between the budget process in the Money Bills Act and Section 74 of the VAT Act. You could rewrite Section 7.4 of the VAT Act to say the announcement is in place until or unless Parliament rejects it in the fiscal framework. But that's not what Section 7.4 says. It requires legislation. So unless until Parliament passes legislation, that announcement will be in effect. So I agree with you that there's a problem here, that the process, at the first point where Parliament decides on the appropriateness of the VAT increase is when they vote on the fiscal framework. But that doesn't affect the announcement. It's also possible under Section 7.4 to have said the announcement would come into effect on the 1st of April, before Parliament even had an opportunity to vote on the fiscal framework. So I don't see these as problems with my case, lady. I see these as reasons why Section 7.4 is problematic.
But 7.4 is not untethered to the annual budget.
Yes, that's correct.
So that provides some grounding in a way. It can't just come out of nowhere.
That's correct. Yes. Just to round up on these opening remarks, and to address the question you raised, my Lord, the argument that the DA is only here because they've lost in Parliament. Our case is that we didn't lose in Parliament. Our case is that Parliament followed an unlawful process and did not take a lawful decision about the fiscal framework and therefore about the VAT increase. So we said we didn't lose in Parliament. That's why we're here. And then if I can then turn to the VAT decision. And I just want to emphasize quickly what we said are three important facts, which are common laws, and that determine the outcome of this case with respect to Section 7.4. The first is that the VAT is intended, the VAT increase, and the power in Section 7.4 is to raise revenue. It's not to regulate behavior. And that appears from the Minister's answering affidavit, paragraph 45, page 03-23. He says that the increase reflects my best judgment on how to raise the revenue required to fund public goods. No argument is made that this is a regulatory change. And this has become very important when we look at the case law. The second is that it's common cause that it is not possible to repay VAT to consumers. So the VAT that consumers, you and I and everybody in this room, will start paying on the 1st of May when we go to the grocery store, when we pay our bills, can never be returned to us. It is not possible to return that money. It will be forever in the National Revenue Fund. And that's because of the nature of that. Because it's paid by the consumer to the vendor, from the vendor to SARS. And so SARS will know how much the vendor had paid and can return money to the vendor. But how does the vendor give it back to the Pick and Pay, give it back to the thousands of people who came shopping? So, oh, I owe you R3.22. I owe you R4.76. It's not possible. It won't happen. And that's again accepted by the Minister.
Well, what happens if there are emergencies that require some reaction from the Treasury and the Minister at the point in time? Isn't Section 7.4 designed for that? That when it is needed and there's a demand for the alteration to take place because the country needs it, the parliamentary process is taking too long. Wasn't that 7.4 designed for that eventuality?
Yes, so thank you, Lady. There's a few answers to that. The first is the point that Justice Savage raised, that it can't be for an emergency because it can only be once a year taking a budget announcement. If there's a shortfall in August, you can't use Section 7.4 to suddenly raise that and increase the revenue. So it's part of a long-term planning process, not part of an emergency revenue-raising process, because it's linked to the budget. That's its purpose. So that's the one part of the answer. The other part is that it's true that in the past, when Parliament has considered a budget, it takes many months to do it. But if Treasury says, and the Minister of Finance says, we urgently need this money, I have a cash flow problem, I am not going to be able to pay salaries in 2 months, I need more money, the only way I can do it is VAT. He can table a money bill to increase the VAT rate by amending Section 7.1 and ask Parliament to deal with it urgently. There's no reason why Parliament can't act within a month or two,
So
or even quicker if they need to.
What's the purpose of 7.4?
It's a good question, Malay.
Because 7.1 is there that states what the rate is. But what is the purpose of 7.4?
I think the purpose that the Minister defines it is he talks about financial flexibility and stability. So what he's saying is, from the time I proposed the budget, I need the revenue to raise as I proposed it, because that's how Treasury has planned it. But Treasury doesn't have to operate that way. Our budget doesn't have to operate that way. We've given references to various other countries that don't work this way, where that is not raised by the executive, where that is raised only by Parliament. And those countries operate perfectly efficiently. Ireland, Germany, New Zealand, Australia. They all manage without this power. So I think the power is...
But Mr. Bishop, you must concede there are also countries that work like us.
That's correct.
And there's nothing wrong with that either.
Well, my Lord, whether there is or not is a question of constitutional law.
Yeah, but
Peculiar to each country. We say, for the reasons I'll get to, that under our constitution, there is a problem with it. But yes, I accept there are other countries that have similar provisions. A lot of them are a lot more limited than ours. Ours is exceptionally broad, and I'll get to why. So maybe the second fact I want to stress was that it's impossible to repay. And the third, which is one that I mentioned previously, is that Parliament has, at best, not lawfully endorsed the VAT increase.
So can I just go back to impossible to repay,
Yes.
and maybe connecting that to the issue of harm for now? I'm not going there yet. Isn't the money going to the National Revenue Fund for the purposes for the benefit of the public? So when you say repay, isn't that at least the money goes to the benefit of the public? It's not necessarily lost.
So yeah, that is an argument the Minister makes. And effectively the argument is that this tax that I've imposed is justified because it is a tax. Because that's what happens to taxes, if they go into the National Revenue Fund. That's the definition of a tax under Shuttleworth and Casino Association or Club. So he's saying, because it goes into the National Revenue Fund, therefore it's justified. But that means that every executive tax will be justified because it goes into the National Revenue Fund and is used for the common good. But the other answer, my lady, is there's a difference between me having however much I would spend on VAT in the year that the increase would be in place. Let's say I spend 5,000 Rand on VAT. That's 5,000 Rand I can't spend on what I want to spend it on. It's money out of my pocket. Yes, it will go into the National Revenue Fund and it will be spent on other goods, but I won't have the money. And that's a harm when the decision to take that money from my pocket, put it in the National Revenue Fund, is taken by somebody who doesn't have the lawful power to do it.
But how will that change if, for instance, Parliament introduces the VAT?
The DA has no problem with Parliament voting for the VAT increase. If Parliament does it, then that's a choice that Parliament has made. The Constitution gives them the power to do it. Our objection is to South Africans being taxed unlawfully. We don't have an objection to South Africans being taxed lawfully. So, ladies, just to refocus, so I'm dealing with the VAT challenge. I'm going to start briefly with what we're here asking for suspension. It's interim relief for asking for suspension. We say the test is the EFF versus Gordon test. Is it just and equitable? I'm not going to take the court to it, but the reference in that bundle is page 70, paragraphs 1135. And what Justice Japta there says expressly is this is a lower test than OTA. Not the OTA clearance for cases test. When one asks for suspension, it's just what is justice and equity. I'm not going to make too much of this because ultimately the considerations the court will have to consider whether it's under an interim interdict or suspension are largely the same. The court must look at the prospects of success and must weigh the harm of granting versus the harm of refusing. We just think that the test is lower when the court conducts that exercise. That's as far as the submission goes. So that then goes to the first issue, which is what are the DA's prospects of success in Part B, in its constitutional challenge to Section 7.4. And I want to start by looking at what does Section 7.4 mean, how does it operate, and then going to argue that the Constitution, as an absolute rule, does not permit Parliament to delegate taxing power to the executive, and that the case law is crystal clear on that. And I'm then going to deal with why the court, when it weighs the harms on either side, should suspend the minister's decisions. So to begin with the Section 7.4, as the court is aware, the rate is set in section 7.1. There are other tax statutes where the rate is not set in legislation. It's set in schedules or it's set in regulations. That is set in the act itself. So how does section 7.4 operate? The first point, which is one that Justice Savage made, is that can only be done at the budget amount. So that's the trigger for the minister's power. And the minister makes much of this, and he says, oh, this shows what a public announcement it is. I must do it in Parliament, everybody will know about it. And that's true. But the other reality about it is that there will be no public process before the announcement. No participation, no draft put out for public comment. The minister announces it, and then it comes into effect on the day he says. It could be the next day. And so this is casino association. In both of those cases, there was public participation about the regulations before they were enacted, and those regulations changed the tax rates and were then challenged. But at least there was a regulatory process for public participation. Here, everything happens behind closed doors in Treasury. And then his announcement comes into effect whenever the minister says so. So the second point I want to make is that what section 7.1 says is that the VAT rate specified in this section is to be altered. So that's a reference back to section 7.1. So it says in express terms that what is being altered is 7.1. That's what section 7.4 says. The minister is given the power to alter the VAT rate in section 7.1.
Does that amount to an amendment of section 7.1 in the sense that when the minister says this is a temporary power that is exercised and pending the enactment of legislation by Parliament, if legislation is not introduced, then it automatically lapses. That's what the minister says, and then we revert back to what is actually in 7.1.
So I must accept, my lady, that it's temporary, and I'm going to get to just now exactly when the period would lapse. But so I accept that it is temporary. But the minister, in the next announcement, could make the same alteration that would be in effect for another 12 months and another 12 months. So he'd have to keep doing it every 12 months. But I accept it's temporary. I submit it is an amendment, because it may be a temporary amendment, but it's still an amendment. Because, and I'll explain now why, the only way to undo it is to amend, for Parliament itself to amend section 7.1. But whether it's an amendment or not is not central to the DA's case. Because we say, well, the problem here is that it's a power to impose a tax. And whether that's done through an amendment to the statute or through schedules or regulations, the Constitution prohibits it either way. It's worse because it's an amendment to the statute itself. But I don't have to win that fight to win the challenge to section 7.4 about is it technically an amendment or not. So that's my answer there. If we then look at the question you're asking about when will it lapse? So what the text says is, subject to Parliament passing legislation giving effect to that, so it's in effect for 12 months, subject to Parliament passing legislation giving effect to that announcement within that period of 12 months. So it seems to me that there's various possibilities that can happen in those 12 months. So the one possibility is that Parliament passes legislation that gives effect to the minister's announcement. So it passes legislation giving effect to the 0.5% increase. Then the announcement will lapse because it will be replaced by the amendment to section 7.1. The other possibility is that Parliament passes legislation with a different increase, a 0.1% increase or 0.25% increase. Then it will also, the announcement will lapse on the date that law comes into force, because it will be replaced by the new change. But there's two other possibilities. Parliament does nothing. So it doesn't, within the 12 months, vote at all on an amendment to the VAT Act. Then it's in force for the full 12 months. I think that's very clear from the text of the statute. I think the more difficult question is what happens if Parliament, the minister puts up a money bill before Parliament proposing the VAT increase, and Parliament does not adopt it. So it either doesn't adopt the Act at all, or it removes the amendment to section 7.1, and then adopts an Act without any VAT increase, but with other changes to the VAT Act. What does that mean? And I think it's very uncertain whether what the case is then is whether it would continue for 12 months, or if it would lapse on the date that Parliament implicitly rejected be increased.
But isn't the latter more sound?
I think the latter is more principally sound, but it's not consistent with the text, is the problem. Because what it says is that subject to Parliament passing legislation, giving effect. So, but I don't think this again is vital to my case, because whether it's in place for 4 months or 8 months or 12 months, it's still unconstitutional. But that's our view on how Section 7.4 operates. But I think what's important about this analysis of Section 7.4 is the only way for Parliament to really stop the announcement is for it to amend Section 7.1 itself, either to adopt the minister's rate or some new rate, or to, I suppose they could amend Section 7.1 and impose the same rate again. That would stop it. But they have to amend it to get there. So maybe that's how Section 7.4 operates. I now want to get to what's really the core of this part of our case, which is that Parliament cannot delegate its taxing power. And we submit that this is a fundamental and absolute principle if one looks at the cases. And I want to take the court through these cases, because what they say is that there's certain powers in the Constitution that are expressly assigned to certain bodies. And when the Constitution does that, those powers cannot be delegated. So the Justice Alliance of South Africa case is an example. The power to determine the Chief Justice's term is given only to Parliament. It cannot delegate that power to the President. Taxing is the same. So if the court can go to that bundle, and we'll start with Fetscher, which is really the source of this. So the issue in Fetscher was really about whether a decision by a municipality to impose rates as part of its budget was administrative action or legislative action.
Where will we find Fetscher in this bundle?
The part I will take you to is at page 94, which is paragraph 45 of Fetscher. And this is where the court says, it seems plain that when a legislature, whether national, provincial, or local, exercises the power to raise taxes or rates, or determines appropriations to be made out of public funds, it is exercising a power that under our Constitution is a power peculiar to elected legislative bodies. It is a power that is exercised by democratically elected representatives after due deliberation. So that's really the founding source for this argument. And then there's 4 cases that come after that. And I'm conscious of time, so I'm going to go through them fairly quickly. But the next one is Shuttleworth. So Shuttleworth is about Mr. Shuttleworth, who had a windfall when he sold his company and made, I think it was 2.5 billion rand that he wanted to take out of the country. And SARS says, well, if you want to take it out of the country, you've got to pay 10% in terms of the Customs and Excise Act. And Mr. Shuttleworth said that it was a tax and it had been delegated from Parliament to the President to the Minister, and that was unlawful. And what the court, this is page 237 of the bundle, paragraph 42, is it endorses what was said in Fetscher. So what Moseneke ECJ says is, a blissful starting point would be to affirm that the power to tax residents is an incident of and subservient to representative democracy. The manner and the extent to which national taxes are raised and appropriated must yield to the democratic will as expressed in law. It is the people, through their duly elected representatives, who decide on the taxes that residents must pay. An executive government may not impose a tax burden or appropriate public money without due process and express consent of elected public representatives. That authority, and indeed duty, is solely within the remit of the legislature.
Does 7.4 not do that? Does
So
7.4 not do that by within the 12-month period having Parliament consider the increase?
for 2 reasons, no. Because the VAT increase is immediate and irreversible. So it comes into effect before Parliament acts, and it cannot be undone after Parliament acts. It may be different with other taxes like the income tax, because I'm not here arguing about the Income Tax Act. I'm just saying that is the worst example that you can think of. But with the Income Tax Act, if there was a similar provision, and Parliament eventually does not amend the Income Tax Act, people can either withhold the tax because it hasn't become due yet, or they can get a refund from SARS. But it's just not possible with that to repay the money. And so that's what makes that unique here. when it comes to these types of provisions that provide for executive action and parliamentary action.
So do I understand you correctly? You are saying that even if Parliament has oversight over the minister, that's after the fact, and the tax rate cannot be undone.
Yes.
Parliament might change it, decrease the percentage, but the amount that was announced by the minister stays for that period of time until Parliament changes it.
Yes, and it can never be undone. The money can never be repaid to the residents. And they would have paid a tax imposed without the duly elected representatives having had any say in it.
But Parliament agreed to this legislation.
Well, that can never be a reason why legislation is constitutional. You can never say, well, Parliament adopted it. Our whole point is that Parliament does not have the constitutional power to delegate its taxing power to the minister. So with respect, the minister makes that argument, but it's not an answer. So how does Shuttleworth comes out, the case comes out against Mr. Shuttleworth? Why? Because the court says there's a difference between regulating behavior and imposing taxes. It says Parliament can delegate the power to regulate behavior, but not the power to tax. And it says what's going on here with imposing charges on taking currency out of the country is a regulatory measure, because what you're trying to do is prevent Mr. Shuttleworth and other billionaires from taking their money out of the country, because that's bad for the rand. And so it's a regulatory measure. And therefore it could be delegated. But Shuttleworth affirms the principle in question. We then get New Africa, which everybody gets very excited about. But New Africa is exactly the same as Shuttleworth. It's exactly the same
Well,
case.
not according to the minority judgment.
Well, with respect, it's two judges, Judge Rogers and Judge Cullivan. They sort of no binding precedent.
I know that, but their reasoning looks to be sound.
But their reasoning was not adopted by the majority. And so with respect, this will be bound by the majority's reasoning, which is very clear. And the majority's reasoning is exactly the same. It applies Shuttleworth. This is at paragraph 105, where it quotes paragraph 48, which says, the question is it a tax or is it a regulation? And it concludes that the issue there, remember that the issue in New Africa was about diplomats buying alcohol and cigarettes and then selling them on. So, and the changes are made to regulate the behavior, to stop the diplomats taking advantage of this loophole and stop them not paying the VAT and customs duties that they should pay. And
But if you look at it narrowly in terms of the broader scheme of the VAT Act, holistically, isn't the minister just regulating the VAT percentage-wise?
Well, it's not about whether you're regulating the rate, it's about are you regulating behavior? Are you trying to influence the way that people act? So there may be other parts of the VAT Act which would be regulatory in nature. So if you change what are zero-rated goods or you change the exemptions, you're trying to get people to donate more money to charities, to buy certain goods and not others. Not this case, but that may be regulatory.
But doesn't it regulate our behavior, becoming poorer?
What? It regulates our bank balances. I'm not sure it regulates our behavior. Because we still have to go and buy the goods and services that we need. We're just going to have to pay more for them. And this case is not made by the minister. The minister never says in his answering affidavit, this is a regulatory measure. He says the opposite. He says this is a revenue-raising measure. His whole defense is, we need the money, not we need to stop South Africans doing X, Y, and Z. It's common cause, this is a tax.
Yeah, but the minister also says that in certain circumstances, the plenary powers that he's got is not unlawful because it's limited and Parliament has got oversight over it.
Yes.
So it's not as if he goes on his own and do things that's not within the purview of Parliament. It's not similar to the Smith matter, where the drugs and cannabis was sort of looked at.
Yes. So our answer to that, Lord, is it's not relevant if it's a tax. This question, the New Africa case that they said, where they say we're delegating plenary powers and it might be lawful, we've got to consider all these factors. That's relevant if it's not a tax. But the cases from Federal through Shuttleworth, through New Africa, through, I'm going to get to Senior Association and McLeod, are crystal clear that once you find it's a tax, it cannot be delegated. You don't get to any other place. Parliamentary oversight irrelevant.
But is New Africa also not, in the true sense of the word, a tax? Schedule has been changed, and therefore those people that wants to buy alcohol duty free must now pay more for it.
Well, look, that wrong. Because he was representing one of those. Yeah. He was representing Africa. But the key was representing SARS.
So you got
They're not based on.
What the court says in paragraph 110 is which is at page 185 of the bundle, is he says what one gleans from the long title is that the Customs Act mandate is to control the importation and use of certain goods. In this matter, the minister highlighted that the primary reason for the amendments was to curb abuse by diplomats. This in turn informs us that the charge is in fact regulatory in nature. One can disagree with the court's assessment of that, but that's the reason that he gives for upholding it. He says it's regulatory, therefore it didn't need to go through the money law procedure. And that's the Russia dissidendi of the case. So, and that's then applied in casino association. So New Africa happens in 2023, in October, next month, November 2023, we get casino association. And what's fascinating about this is it doesn't even cite New Africa. It cites Shuttleworth and Fetcher. And it says, it quotes Fetcher, it says the same thing. This is paragraph 42, bundle page 29. It is settled that the power of taxation...
So you're going too fast for us, Mr.
Yes,
Chairman.
please. Slow down a bit.
You're going too
Mr.
fast for us.
I'm so nervous about time. It's page 29 of the bundle,
Yeah.
paragraphs 42 to 43. And what Mpofu-Walsh AJ says is, it is settled that the power of taxation and appropriation of government funds are reserved for legislatures, and that the executive has no power to raise taxes itself. And then it applies the test from Shuttleworth. It changes it slightly because it says we must focus not only on the dominant purpose of the statute, but whether the charge has a nexus to the regulatory scheme. But that's not really relevant here. Ultimately, what it concludes is that this is also a regulatory, not a regulatory issue. It says this one here, this power to change the gambling levy. And I want to emphasize this because the gambling levy was imposed by the Northwest Act. And then the minister is given the power to set the rate. It says that power is the power to raise a tax, and therefore it's unconstitutional. Doesn't engage. After New Africa, in any of these questions about balancing plenary powers and when is it possible, it says it's a tax, end of story. And the court reaches exactly the same conclusion a year later in Mpofu-Walsh. Mpofu-Walsh is a case about provincial legislation that affords traditional leaders the power to impose traditional levies on their community.
So if I understand your argument by referring to all these cases, you're saying that we must look at the dominant purpose of the Act. And if one has regard to 7.4, it's simply clearly to raise tax,
Yes.
not to regulate conduct.
And once you reach that conclusion, it is unconstitutional without more. Yes, that's what the case has said.
Is that you mean your case is so simple?
Yes, very simple.
Mr. Bishop, is the tax rate raised in 7.1? And then for purposes of Mpofu-Walsh and Casino Association, that's where the raising takes place. And therefore the amendment to the rate that occurs in 7.4 is something different.
Yes. So this is an argument that's raised by the minister. So I've already explained, I think that's inconsistent with Casino Association, because the same structure was in Casino Association. It was set in one section and the power to, it was imposed in one section, and the power to amend was given in another section. It's also inconsistent with Fetcher, because in Fetcher, this is page 95 of the bundle, paragraph 46. The court, just after it says what I read out to you about democratically elected legislators and imposed taxes, it says that the argument of the challengers there was that the resolution had none of the ordinary characteristics of legislation, and that the levy was not of general application, applied for a limited period of time, and did not have to be promulgated. We have already decided that the resolutions to adopt the budget were not administrative actions, and this is the important part. The resolution of the TMC, taken for the purpose of raising the levy and paying the subsidies, formed an integral part of the adoption of the budget, and as such constituted the exercise of taxing and spending powers. Such powers are constitutionally vested in the legislature, and their exercise is performed not administrative actions, and even though it's temporary. And Casino Association says even though it's imposed in another section when you change it, and one can just think about it logically. The minister could, under 7.4, decrease VAT to 0%. He could raise it to 100%. And I think it would be strange to say that when he did that, he was not imposing a tax or undoing a tax.
So you're saying we don't need 7.4 at all?
No, it should be. That's going to be our case in Part B. It should be struck from the statute completely, yes. That's the case.
So what happens if there is, what contingencies are there in place when there is a need for the minister to intervene at a point in time?
He must ask Parliament to pass legislation urgently to amend Section 7.1 of the VAT Act.
I mean, going back to my initial question, isn't this a recognition that those processes take too long? And so Parliament recognized that by introducing 7.4 to say that for an interim period, with these conditions, we are going to give you this power. But this power is not absolute because at the end of it all, we have the power to change, to alter what you've actually put, but you're just putting this for this period.
My first answer, ladies, is that whether it's convenient or useful or expedient is irrelevant because Parliament doesn't have the power to do it. It may be good policy, but the law that the Constitutional Court has said is that Parliament cannot delegate the power to tax. I still want to get to Mhlaba.
Yes,
I think
yes.
it's very clear Mhlaba,
Yeah.
but that's the first part of my answer. The second part said there's many other countries that don't need this. This isn't universal. The third is this is not an emergency power because it's linked to the budget. So it's part of the planning process. And the third is it may be true that Parliament thinks this takes too long, but that's can never be a justification for delegating their taxing power, saying we're too slow, therefore we're going to ask the minister to do it. The solution is for Parliament to act more swiftly. And the Constitutional Court has said, for example, in Doctors Delight, that when Parliament needs to act urgently, it can.
With regard to the constitutional scheme currently, it's only the Minister of Finance that can introduce a money bill. No other member of Parliament may do it.
That's another problem with Section 7.4, because the minister controls what gets in front of Parliament. He controls when it gets in front of Parliament.
So even if the parliamentarians shout and scream about the VAT rate, they can't introduce a bill or money bill to saying we can have one to lower it. They have to wait for the Minister of Finance.
Yes, and if the current Minister of Finance won't do it, they can always get a new one by electing a new government. But yes, I mean, those are the only powers that Parliament has. No, I didn't mean that facetiously. I meant that's Parliament's power.
Is your client so eager to be
Exactly.
to take over Parliament?
But that's the lever that Parliament has, because you're right, Parliament itself cannot introduce the bill. It must wait for the Minister of Finance, or if it's so upset with the Minister of Finance for not introducing a bill, its only remedy is to a motion of no confidence in the Cabinet. That's the constitutional scheme. I'm not talking about politics. I'm not a politician.
No. I'm just saying. But as my learned colleague, presiding judge, indicated, isn't that the reason why Parliament has introduced 7.4?
I'm not sure that that's a reason for 7.4, because without 7.4, the minister can still introduce a money bill to amend the VAT Act at any point in the year if there's an urgent need to raise cash flow and ask Parliament to deal with it urgently. It cannot be, I would submit, that Parliament says we sometimes take a while to deal with legislation, therefore we're going to delegate this core power this core democratic power to the executive, when there's no legal reason why it cannot act swiftly, and there's no practical reason why it cannot act swiftly. All we have is that it hasn't done so in the past. And then if I may briefly, let's go to Mhlaba, because I submitted some, it is important, because it's the most recent case, it's from November last year. So it's at page 158 of that bundle, paragraph 17, where Justice Duran says, this court has repeatedly held that there must be a direct constitutional source for the power to impose a tax. The Constitution only affords a taxing power to the three elected spheres, and the power to tax cannot be delegated to the executive.
And I noted that C refers to Shuttleworth.
Yes, because that's what Shuttleworth says. But Shuttleworth just finds it's not a tax. And then in paragraph 20 on the next page, The Constitution reserves the taxing power of the legislative body.
Sorry, paragraph?
Paragraph 20.
It's on the same page.
Oh,
Same page.
my notes are incorrect.
Mm.
The Constitution reserves the taxing power for legislative bodies, and that when it permits the imposition of tax, it does so expressly and regulates how the power must be exercised. Legislative bodies can delegate the power to regulate, but not the power to tax. Full stop, end of story. No balancing act could be performed. And that's the way the case comes out. It considers, is this a regulatory charge or is it a tax? It finds it's a tax and it says, therefore, it's unconstitutional. Because the provincial legislature purported to delegate it to traditional leaders and the family. So we submit that we have very, very strong prospects of success in Part B.
Okay, so we don't need to finally decide this point, this issue, because...
Sorry.
Yes, go ahead.
No, we're not asking you to declare Section 7.4 unconstitutional, but we submit it is important that there is no answer to this. That when we get to Part B, the prospects that we will win Part B are extremely high. And that weighs when this court is performing the just and equitable analysis of whether to suspend the minister's announcement. That's obviously an important factor. And that's why I've spent quite a lot of time on it. Maybe I want to deal with some of the minister's defences. Most of them have been raised by the bench. But if I may just quickly make sure I've covered all of them. The one argument that the minister raises is that even if we are successful in Part B, the Constitutional Court may ultimately suspend the order of invalidity. And so if it suspends the order of invalidity, it would mean that the minister's announcement would still be valid. So the argument is the relief we seek in Part B doesn't necessarily entitle us to the relief we seek now in Part A. So we submit that there's a few problems with that. The first is you've got to distinguish between retrospective effect and suspension. We accept, and you'll see the relief that we seek in paragraph 3 of our notice of motion in Part B, says that the order must have effect from the 1st of March 2025, because we don't want to undo the 2018 VAT increase. There was a VAT increase in 2018, we don't want to undo that. We want to stop this one coming into effect. And then so it must operate from the 1st of March. In terms of suspension, we don't think there would be any basis for the court to suspend the order of invalidity, because for all the reasons I've already given, it's not necessary for the minister to have that power. And so there would be no basis for suspension of the order of invalidity.
Mr. Bishop, in terms of the announcement, the minister also announced that next year there's another 0.5% from March 2026. Yes. What about that?
So I think that's dealt with in the relief we seek in Part B, which we hope will be determined at least by this court before then. Yes. So paragraph 3 of our Part A relief applies to both. Sorry. So this is asking this court. Paragraph 3 is the operation of the first respondent's announcement on 12 March to increase the rate of VAT by 0.5% with effect from 1 May and by a further 0.5% with effect from 1 April. So we're asking for the suspension of both. Because it was a single announcement. And it's been dealt with by Parliament also as a single issue. So Milady, just to conclude on this question of the prospects of success, we say it's common cause, it's a tax, it's immediate, it's irreversible, it's unconstitutional, full stop, end of story. We make a separate argument in our papers, which we'll pursue in Part B, that it's plenary power because it's to amend the statute, effectively. But we don't have to convince this court or the Part B court about that argument. I think that there's a tension between the decision in New Africa and the decision in Smith, and it's difficult to know how you square those two decisions. But it ultimately doesn't matter, because even if Parliament had delegated the power to the minister to change the VAT rate by amending a schedule or by amending a regulation, it would still be an impermissible delegation of the power to tax. We submit it's made even worse because the rate is set in the Act itself. But that's not necessary for us to win the challenge. So I then want to get to the question of this court's just and equitable power. And why it should exercise that to suspend. So we submit you've got to weigh the harm of not suspending versus the harm of suspending. And you've got to do that cognizant of what the position is in Parliament. And we submit that there's three important factors. And I'm going to get to the facts on this when I get to the fiscal framework challenge, but I submit that I will show to this court that Parliament rejected an unconditional VAT hike. That the only VAT hike Parliament approved when it considered the fiscal framework was a conditional one, in the sense that it was conditional on the consideration of further alternatives and a vote in Parliament on whether to adopt those alternatives. So Parliament has not endorsed this VAT hike. The decision that Parliament did take was an unlawful decision. And if one looks at the public statements of political parties and one counts the numbers, in both the National Assembly and the NCOP, at least at present, if the vote was taken today, the VAT hike would not pass. So I'm not saying that means when it gets in 3 months, 3 months is a long time in politics, it may be very different then. But there's at least a very good possibility that Parliament will ultimately reject this VAT hike. And that's an important consideration when this court decides whether to suspend or not. Because if Parliament had unanimously endorsed, that every political party had said, we agree, we must have a 0.5% VAT increase, and I was here asking this court to suspend it, I would have a difficult case. Because even though there might be a technical unconstitutionality, in substance, there would have been endorsement by the democratically elected representatives. But that's not the case here. Those are not the facts for this court. The facts for this court are that, at best, it's uncertain whether Parliament will endorse it, and in fact, Parliament has not endorsed it when given the opportunity to do so.
What is it that was adopted? Because the fiscal framework had that increase as part of the report. And so when the report is adopted, what is it that's being adopted?
Yeah, I don't want to avoid the question, but may I answer it when I get to the challenge on the fiscal framework?
Okay, I thought you were getting
moving back and forth, but I will answer the question directly.
That's fine.
So that's the first point. The second point is, what is the harm of allowing the VAT increase to come into effect? And we submit that there are two important harms. The first is that it's
doesn't it speak for itself? I mean, if you increase the VAT rates, you can't claim it back.
Yes. So it's, and I've dealt with this. The first point is irreversible, it cannot be undone. So this is unlike OTA. So OTA is an interesting example. Remember, that was about e-tolls. And one of the things that Justice Ngcukaitobi said there is that there's no irreparable harm because you'll be able to bring an unjust enrichment claim to recover your e-tolls that were unlawfully paid. And that would be possible there because you would know how much e-tolls you paid because the camera would flash at you every time you drove under the boom and you'd get a bill for you had all these e-tolls. And if ultimately it's declared unlawful, you can go and reclaim that money. But that's just not possible with VAT. Practically it's impossible. And everybody accepts it's impossible. So that's the one important thing. The second important point is that the effects of the VAT increase will be negative and will be felt most severely by those who have the least. And this is not the DA's view. This is the view that adopted by the committee. So if the court goes to page 02-183 of the record.
Let's repeat that.
My learned friend, Mr. De Beer, should be directing you.
Yes, I've got that. Thank you, Mr. De Beer. Yeah, 02183.
Yes, paragraph 4.3.1.
What is that?
That's
it's on the case
final report of the committee that served before the National Assembly.
It's 02183.
So what the committee... So it's an annexure to the founding affidavit. It's annexure DA 13. In my papers, it's saying having page 196, but I'm using trying to be technologically advanced in these tests. Do you have it, Louis? So what the court says is the committee is talking about the concerns. So the concerns raised include the VAT increase would disproportionately impact middle and low income households, not just the poor. Would cut into households' discretionary spending, diminishing their quality of life of of life and potentially exacerbating poverty and inequality. So this is recording the submissions that were made. Further down the last paragraph, the stakeholders were further concerned that VAT is a regressive tax that disproportionately affects the working class and struggling businesses. And then the committee adopts those. So at page 02-199.
But you didn't finish the sentence there.
Sorry.
It says here, it is not backed by concrete evidence that it is less harmful to growth than other taxes, and it has not been researched enough to determine its potential impact and implication, and its alternatives have not been thoroughly interrogated.
I agree with all of that.
Okay.
I'm just worried about time. I agree with all of that. So then at 02-199, at paragraph 6.28.3, so the committee notes that increasing VAT would have a disproportionate adverse effect on lower and middle income households, exacerbate inequality in the cost of living due to its regressive nature. So the burden is although people with higher incomes pay more VAT, they can afford it. People with lower incomes pay in total less VAT, but it's a bigger proportion of the income that they pay, so they feel it more. And so that's endorsed by, I don't want to take the court all of it for time reasons, but if I can just briefly give the references. By the Budget Office, where it says an increased VAT will disproportionately burden middle and low income earners. That's at page 06-79.
But are you not taking us to the question of whether or not VAT is bad or good, is good or bad?
No, Milady, I'm taking, that's a decision for Parliament to make.
Yes.
But this court has to decide whether to suspend the announcement or not.
But I mean, if you talk about the impact that it has on low-income households and the impact that it has vis-a-vis the high-income households, isn't that going to whether or not VAT is bad or good?
No, Nelly, good. Well, that's ultimately a question Parliament will have to decide on its merits.
Yes.
What I'm saying to this court is you're confronted with not a decision by Parliament, but an announcement by the Minister.
Yes.
That announcement was made in terms of an unconstitutional law and has not been endorsed by Parliament. In those circumstances, one must consider the need for the VAT hike, which I'll get to, and also the consequences of it. This court must consider that in order to decide whether to suspend it or not. This court may suspend the VAT hike and stop it coming to effect, and Parliament may still say, we still think it's a good idea, and we're going to exercise our democratic will and bring in a veto.
And the court can't interfere with that?
It mustn't. It's not for the Minister and it's not for this court to decide that ultimate question.
Yeah, because then the court will interfere into the reign of Parliament, which it can't.
Just as the Minister has. And so this court should stay out of it, but it can't stay out of deciding what happens in the interim. And it can't close its eyes to what the consequences of imposing the hike would be. But leaving open the ultimate question of how Parliament, when it actually exercises its power, weighs these competing factors. This court must not decide.
You have 15 minutes. Just as a reminder. I'm not rushing you.
So yeah, we also refer to, but the point is made. So those are the problem, the harm that will be done if the announcement is not suspended. 13 billion, sometimes it's 13, sometimes it's 13.5 billion rand. But we submit that that's firstly the wrong number. 13 billion is what would be collected over the full 12 months of a 0.5% VAT hike, the estimated revenue. But what we're asking the court to do is not to say you cannot have a 0.5% increase for 12 months. We're asking the court to say you cannot have a 0.5% increase until Parliament decides. So when Parliament decides, votes on the bill that is before it, which amends Section 7.1 to increase the VAT rate, if it adopts it, it will come into effect. And if it rejects it, the Minister can hardly argue that that's harm from that point onward, because then Parliament would have said we don't want the income, and we've either found other income or we've reduced expenditure to address it. So the question is for how many months until Parliament takes a decision. We say it's likely to be in June or July, so it's 2 to 3 months from 1st of May. And how much is lost then? So if it's 13 billion over 12 months, it's about 1.1 billion a month. So we're talking about 3.3 billion. What percentage of revenue is that? 0.099%. Less than 0.1% of total revenue.
Mr. Bishop, can I ask you this question? Do I understand it correctly that the minister did introduce the money bill?
Yes. I forget the name, it's got a long name. It's the Revenue and Something Matters Amendment Act. But yes, there's a bill before Parliament that to amend Section 7.1. It's attached to the founding papers. Yes.
So even if, and that's still a big if, we're with you, Parliament can, for argument's sake, tomorrow change it and introduce the VAT
Yes.
rate. And that's it.
You probably couldn't do it tomorrow. But
No, I'm just saying it.
It could fast track that process because, well, I should give an honest answer to this. It depends what happens in the second part of the case. Because if this court sets aside the fiscal framework, Parliament would first have to adopt a new fiscal framework before it can consider any of these bills. Because under the Money Bills Act, you first need the fiscal framework before you can get into DORA and Appropriations Act and Revenues Act. But once the fiscal framework is lawfully adopted, Parliament, these revenue bills can immediately be considered. There's no ordering in the Money Bills Act. It says you must do DORA first and then you must do appropriations, but it doesn't say when you must deal with other revenue bills. So those could be dealt with. The other point, so the first point is it's a very, very small loss in income we're talking about, less than 0.1% of revenue.
But that revenue goes to the very poor. I mean, the minister says it's going to certain grants. He wants to appoint more medical doctors in the hospitals. It will affect the poor, the poorest of the poor.
So there would be 0.1% more doctors for these 2 months. And the price paid for that is having less money in your pocket. That's the reality.
But isn't that the scheme that we've accepted in terms of the democracy that we're staying in? I mean, this is our... We need the money in order to do all of these things.
The important word in that question, Lord, is democracy. And democracy means a decision taken by elected representatives, not by National Treasury and the Minister without public participation. Democracy means it's taken by Parliament. And so if Parliament adopts it, Parliament adopts it. But if it's not adopted democratically, that trade-off hasn't been made by democratically elected representatives, then it should not be imposed on people. And the other point is about the extent of loss.
I'm just worried about the time. I'm anxious for you to get to the second issue.
I'm almost finished with the first issue, and I think the second issue will be much quicker. I might need another 10 minutes to finish that, but it's going to be much shorter than the first issue. On the Financial and Fiscal Commission also told Parliament that the amount of income they would likely get is less than you expect. If I can just give you the references, it's 02-184 and 02-199. So what the committee accepted is the probability that the proposed VAT increase might not meet the expected revenue in a constrained economic environment and weak outlook. So 13 billion is just an estimate of how much you're going to get, and the committee accepts that it's actually likely to be less than that. But the second harm is the minister says, if you don't give me the 13 billion rand, which we know is really 2 to 3 billion rand, then the government will either cut planned spending or increase borrowing. The answer to that is really that there are alternatives to raise the revenue. And these are also dealt with in detail in the committee's report. Again, I don't want to take you there, but I can give you the reference. It's 02-233, where in particular, the committee notes SARS has estimated tax gap of about 800 billion, and that even with the 30% recovery rate, this could yield over 200 billion in additional revenue. And there's a range of other alternatives. The fiscal framework, and I'll get to this now, maybe, is adopted on the basis that National Treasury must come back and propose alternatives to raise the 13 billion or to cut spending. So it's not that or nothing. There are other options. So maybe for all these reasons, we submit that this court, when it exercises its just and equitable power, should suspend, because the cost of doing so is an immediate, irreversible tax increase that will affect the poorest and the middle income people the most. And the cost of doing it is minimal, less than 0.1% of revenue when there are alternatives to fill the gap. So maybe that brings me to the second part of the case, which is the attack on the fiscal framework. And we submit that there are three issues the court, three primary issues. The first is...
But, I mean, reading what transpired there, it looked like chaos, to say the least.
That's very generous. I'll get to what actually happened, but chaos is a generous description.
No,
Because it's not only chaos, it's misleading.
you need to take us to what the irregularities were.
Yes.
Because
Yes.
the process is quite important for us to understand what is irregular.
Yes, and I will get through it exactly. But if I can just say what we say the issues are is, were the final reports before the National Assembly and the National Council of Provinces consistent with Section 8.4 of the framework of the Money Bills Act? 2, was the process the committees followed lawful and consistent with Section 8.4? And finally, there's a question Parliament raised, which is, should we have challenged the decisions of the committees and not just the decisions of the houses? And just to telescope my argument, even if you accept Parliament's version that the committee's reports just had a non-binding recommendation, it's still inconsistent with Section 8.4. But if you look at what actually happened, it was not a non-binding recommendation. 1, it was a strict condition, and 2, no vote was ever taken on the fiscal framework. And if one looks at what happens in the committees, that's clear. And it's actually common cause. So I want to start very briefly with the purpose of the fiscal framework. And I'm just going to have a long argument on this, but I'm going to summarize. But the purpose is to set the revenue and expenditure estimates for the budget process. And those then bind Parliament in proposing amendments to the various money bills that follow. The Division of Revenue Act, the Appropriations Act, and the Revenue Bill. Parliament cannot propose amendments to those acts that are inconsistent with the fiscal framework. So once it accepts that we're going to have 2.2 trillion rand of revenue and 2.4 trillion rand of expenditure in the fiscal framework, those are the numbers that have to come out the door. So when the Division of Revenue Act, Parliament divides money between the provinces, national and local government, it must divide the 2.4 trillion that it agreed to when it adopted the fiscal framework. And when it considers the revenue bills, it must raise the 2.2 trillion that it agreed to when it adopted the fiscal framework. It cannot spend more and it cannot raise less.
So what happened if Parliament amended the fiscal framework to put the alternatives and removed the VAT increase? What would have happened there?
Then, because it's not the minister that sets the fiscal framework, it's Parliament.
Yes.
So the minister would have proposed one. Parliament could have amended it in different ways. It could have said, we're going to take out the 13 billion and we're going to cut 13 billion from expenditure. And then it would have a fiscal framework that complied with the requirements, and that would have then bound them going forward. They have 13 billion rand less to spend. Or it could have said, we're going to raise the 13 billion not by raising the VAT rate, but by borrowing 13 billion, or by taking it from the reserves, or by raising income tax or some other money. The various alternatives that are in the committee's report. But what it would have to do is balance revenue, borrowing, and expenditure. And whatever it decided when it adopted the fiscal framework would govern what it does when it adopts legislation going forward. But that's why the fiscal framework is so important and why it must be clear and it must be final. You can't have a fiscal framework that is subject to amendments down the road, because then you don't know what your limits are when you pass the Division of Revenue Act, the Appropriations Act, and the other acts, because they're still up in the air. And that's why Section 8.4 says that the report must include a clear statement accepting or amending the fiscal framework.
Can you just take us through the process of what actually happened?
Yes, let me, if I may, I don't want to keep avoiding your question, but I want to deal with it in this way.
Because I think that's quite important, because we have to know what was wrong with the process.
Can I answer first on Parliament's version? Parliament says it doesn't really matter what happened in the committee. look at the report that ultimately served, the final reports
Yes.
that served before the National Assembly and the National Council of Provinces. And it says all those did is they had a non-binding recommendation, and therefore, and those were adopted by the houses, and that's good enough. So one has to look at what is that non-binding recommendation. And it appears at page 02199 for the National Assembly. You don't have to go to this other one, but the reference for the NCOP is 02235. It's identical. And it's paragraph 6.29,
6.29.
and 6.30.
Yes.
The committee recommends that the Minister of Finance facilitate the receipt of substitute revenue proposals from the committee, together with corresponding expenditure savings, that will form the basis of an alternative revenue proposal instead of the proposed 0.5 percentage point increase in VAT, in respect of which the committee has expressed serious concerns. Furthermore, the committee recommends that the alternative revenue proposals and expenditure savings balance the 28 billion rand shortfall, which must effectively suspend the proposed increases, be finalized and submitted by the committee to process within 30 days, and this is very important, for consideration and adoption of this report by the House. So what it's saying is we are having a recommendation that National Treasury must consider our proposals, come back with its own alternative revenue proposals within 30 days for consideration and adoption of this report by the House.
But then what was approved? What was approved?
So you've got to read the report as a whole. The report does contain the statement, having considered the 2025 fiscal framework, blah, 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 the committee accepts the 2025.
Where are you reading from now?
So this is at page 02204. So it's right at the end of the report.
Okay.
So this comes first, the recommendation, and then right at the end of the report, this is tacked on.
But that's belatedly tacked on. I mean,
Yes.
the minutes suggest that something was approved in the committee.
Yes, I'm going to get to that, but I'm saying even if one ignores what happened in committee, even if what happened in committee was squeaky clean, what served before Parliament, before the Houses and plenary, was inconsistent with Section 8. Because although it contains a statement of acceptance, it's subject to a recommendation. It's subject to a recommendation that envisages a change to the fiscal framework. Because if National Treasury comes back with alternative revenue proposals, and those are considered and adopted by the House, that means that there won't be a VAT increase, and the fiscal framework will be different.
But reading between the lines, isn't that what ultimately the committees wanted to achieve?
Yes, but they weren't allowed to do it by the Money Bills Act. Because the Money Bills Act doesn't allow you to set the fiscal framework and say, but we might still change it later. You've got to set it and stick by it. Because it's so important in regulating what happens thereafter in the budget process.
But it requires acceptance or amendment.
Yes,
So why did that committee then not stand firm on giving me?
yes. So if I can let me get to what actually happened in the committee, because I think that's important. So we say that there are 5 important facts. So the first is that the draft reports did not include a statement accepting the fiscal framework. That's common cause. Parliament says the reason is that the committees first had to decide whether to accept it, which is fine if Parliament either amended the report before the vote in committee or took a vote on the fiscal framework in committee. But it is also common cause that the committee did not vote on the fiscal framework.
But what did they do then?
So what they did is that
Is
there were
there a transcript of the meeting?
there isn't what we provided as a YouTube video.
Couldn't find it. Can you maybe send us a link? Someone send us a link.
Yes. I'm sorry,
Because
the other parties have managed
we
to
couldn't
do it.
find it. We tried to locate the YouTube link that you sent us, but we couldn't.
Could you resend it?
Yes, but what I can also try to do is provide a transcript to the court.
Okay.
It would probably take a
How
day.
long are you still going to be? Can we give you 5 more minutes? But when we come back from tea, we're going to adjourn and then come back. Unless you want to close this point quickly.
No, maybe at the tea now, because I'll need 5 to 10 minutes.
10 minutes is a long time. You have to ask your colleagues to give you to borrow some of their time.
In my
Okay.
defense, I'm the only person who has to address both.
Okay, that's
cases.
fine.
So it has taken a little bit more time.
That's fine. We'll give you 10 more minutes when you come back, and we'll have to readjust the time perhaps at lunchtime. All right, the court adjourns.
It contained a description of the fiscal framework, but it didn't contain the statement defined in the final report that the committee accepts the fiscal framework.
It is a statement that you say was important.
So both. So one, the statement was not in the draft report, and the report. So when they voted on the report, they voted on something that did not include a statement accepting the fiscal framework. It included a description of the fiscal framework. What did they vote on? It's a very good question, Lord. So what happened is various amendments, motions are proposed over the 7 hours of the meeting, and those are then voted on. And they're voted up, or they're voted down, but they're all amendments to the report. So various amendments are made to the report. None of these are reduced to writing into a new report that is then placed before the committee so everyone can read it and see what it says.
So when they disagreed, were they at the meeting or were they after the meeting via email and correspondence?
They were done verbally during the meeting. So that somebody will propose. So let's take Mr. Beasley of Action SA, because this is the most important part. So if I can take the court to page 05-19. So this is from Parliament's answering statement. And it's recording the amendment that Action SA proposed. Paragraph 40.
So just give us a moment.
Dash 19. Paragraph 40 of Parliament's answering statement. Do you have it already? So it's an action they proposed the following amendments. The fiscal framework tabled by the Minister of Finance is supported, and I emphasize, subject to the strict condition that National Treasury facilitates. And what goes on is what I read to you previously that found its way into the final report. But the important difference is it's not just a recommendation, it's supported subject to the strict condition that. And that amendment is then proposed by a member of the ANC, accepted by the ANC, seconded by another member of the ANC, and adopted by a majority of the committee as an amendment to the report. And there were various other amendments to the report that were adopted. Amendments proposed by my client, by Mr. Ngcukaitobi's client, were not accepted. They were voted down. But this is all happening verbally. So someone reads out an amendment, the vote is taken, it's either accepted or not, and the committee moves on.
So the secretaries of the committee produced the draft. It's debated in the committee, and amendments are made in the committee, and some are adopted by the majority and some are not.
Yes. And then a vote is taken, do we accept the report? And then people say, but what are we voting on? So we record this in our replying affidavit. It's page, you don't have to go there, I just want to give you the reference, 06/12 from paragraph 27, where we quote various members of the DA, NKP, the EFF, who are all expressing confusion about what are we voting on. Parliament's position is that what was voted on is the report with all the amendments that had been verbally accepted during the meeting, and implicit in that was an acceptance of the fiscal framework.
Did someone clarify, as questions were asked what we're voting on, did someone say, this is what we're voting for? The chairperson saying, this is what we're voting for?
So if one listens to the meeting, it's particularly sort of the last hour of the meeting that much of this happens. Sometimes yes, sometimes no. But ultimately, even after these clarifications, members are raising a concern that I still don't understand what we're voting on. Are we accepting the fiscal framework or not? Because what Action SA says is it says, we are against the VAT increase. Mr. Beasley says that expressly. He says, I want to be clear, Action SA is against the VAT increase. And then he says the amendment that is adopted is, we support is, so I want to get the word correct. Says, the fiscal framework table is supported subject to the strict condition that. And so there's two important points in relation. The one is that there's just never an actual vote on the fiscal framework as it stands. That's never put to the vote, and it's never in the report. The only report that is adopted is support with a strict condition.
But doesn't the fiscal framework form part of it?
But remember, Section 8.4 requires a clear statement accepting or amending. And what's here is acceptance subject to a strict condition. That's what the committee votes on.
But that's not an amendment. Which is
Exactly, and it's not an acceptance in the true sense of the word. So it's neither an acceptance nor an amendment, and so there's non-compliance with Section 8.4. That's the problem. The other problem, Lord, is this is very different from what's in the final report, which I took you to just before the break. There, the strict condition is morphed into a recommendation. But there's the world of difference between a strict condition and a recommendation. Because strict condition means if National Treasury does not come back with alternative revenue proposals, our support lapses. I'm not sure it's a resolutive or a suspensive condition, but either way, the support will lapse because the strict condition is not being fulfilled.
And I just understand, at the meeting itself, the proposal by Actions A was adopted, that's strict condition.
Yes.
But the report, in fact, did not refer to the strict condition of the combination.
Correct.
Okay.
Correct. And so, my
And then also inserted was the acceptance.
yes, which was not in the draft report prepared before the meeting and was never put to the committee during the meeting. The actual.
To which Mr. Brits then responds, is that doesn't think it was discovered. Further the amended version is sent, and that
Yes.
he responds again later that evening.
Yes.
Which also not the success.
Yes. My argument, even if you, my first argument was, even if you accept that just a recommendation, and that is in fact what the committee adopted, that's not consistent with Section 8.4. But it's not what the committee said. The committee said strict condition. It's watered down in the report. But a strict condition can never be, as your Lordship pointed out, either acceptance or amendment. It's conditional acceptance. And it is premised on the idea that the fiscal framework may change because Treasury may come back with an alternative revenue proposal which will be voted on in the House within 30 days, which will remove the VAT.
But can that still happen? We're not past 30 days yet.
Notionally it can still happen, but the point for us is that when Parliament voted on the fiscal framework, the Houses on the 2nd or the 3rd of April, that's what we're challenging as unlawful. And we're saying that was unlawful because they needed a compliant committee report before them that accepted or amended the fiscal framework, and they did not have that before them.
So what did Parliament vote on?
When the plenary, when they voted in the plenary, they voted on these reports that had this, was itself contradictory because it says we accept with recommendation, and did not reflect what happened in the meeting. Because what happened in the meeting was neither a recommendation, it was a strict condition, and it was not an acceptance because that was never.
They voted on reports that were prepared by the Secretary to the committee.
Yes. So
So
draft.
the Secretary took a view that they'd been accepted.
I think Parliament's argument is that they say it's implicit. Because we adopted the report subject to all the amendments we did, implicitly we accepted the fiscal framework. Our point is you couldn't have accepted the fiscal framework and accept Action SA's amendment. Those are mutually inconsistent votes. And so having a clear vote accepting Action SA's amendment means you could not have voted to accept the fiscal framework. Because you
Came up with this acceptance.
I assume the Secretary drafted it, but it would have been approved by the committee. I don't know if there's an answer in the paper to that. I can look it up and give it to you in reply, but I'm not sure exactly who. But ultimately, it would be the chairperson who would have to table the report before the House. He would receive comments from the parties who would object to it, and various parties did object to it. And said, we don't think that was ever voted on. There's all the letters that are attached to my client from the EFF. You say, we don't agree that that reflects what happened in the meeting. But ultimately, the chairperson considered. So, lady, that's why the adoption of the fiscal framework is unlawful. Whether you take Parliament's version of what they pretend happened in the committee, or whether you look at the fact of what actually happened in the committee, either way, it's unlawful. So, that brings me, I've just got three quick points. The first is, there's a procedural or technical argument raised by Parliament to say we should have challenged the decisions of the committees and not just the decisions of the National Assembly and the National Council of Provinces. And our answer to that is threefold. The first is that it's irrelevant. Our attack is on the National Assembly and the National Council of Provinces. And we say those decisions are unlawful because one of the jurisdictional facts for them to take that decision was a report from the committee that was compliant with Section 8.4. So imagine that Parliament took a decision without any report from the committee. That decision would be unlawful and we would just challenge that decision. Imagine they had a committee report before them that said expressly, we have not yet taken a decision on the fiscal framework. And Parliament adopts the fiscal framework anyway. That would be unlawful because it would have been taken without a report compliant with Section 8.4.
They are not have before them a report in terms of Section 8.4. We now know that there had been this problematic process, but then Parliament had before them a report which on the face of it complied with Section 8.4.
So that's why I say the first level of our case is that even if you accept that this report was a reflection of the process out of the committee, it's still not a Section 8.4 report because it's subject to because of the recommendation. And the recommendation anticipates the possibility of changing the fiscal framework. So even if one ignores what happened in the committee and just looks at the final report, we come home. But we say there's an additional problem that the final report before the Houses does not reflect what the committee in fact did. But I can win the case just on the first argument.
I just need to answer the point. You mentioned that they're saying that you should have attacked the report itself.
Yeah.
You're not asking for the setting aside of the report. They say, well, Oratile says that it's a decision on its own, attacked on its own until it starts doing so. Then it stands.
Yes. So we think that that's wrong as a matter of law, and we set out the case law in paragraphs 127 to 128 of our heads, which deals with multi-stage decision making. So where often it happens in a tender context or a regulatory making context, where one body makes a recommendation or proposal to another, and the other body has to accept or reject the proposal or take the final decision. And the courts are very clear that in that context, you only challenge the final decision. You don't have to challenge the previous ones because those have no legal effect. They're just recommending to the final decision maker. And that's the case here. The report of the committee has no consequence other than to trigger the power of the Houses to have a vote. That's the only consequence it has. Because it's the adoption by the Houses of the fiscal framework that then triggers Section 8.9 and Section 9.1. So 8.9 is the one that says what the House has adopted, you cannot propose amendments that are different. And Section 9.1 says once the House, the resolution of the National Assembly triggers the obligation to then consider order. And so the committee has no legal consequence under the Non-Default Act, the committee report. If we come to court challenging the committee report before the House had made a decision, we would have been told you're premature. Why are you here? Wait for the Houses to take a decision. And correctly so.
Can you wrap up?
Yes, so two very brief points. Just the difference between our approach and the EFF's approach on this issue. We ask for final relief. We want the decisions of Parliament set aside. The consequence will be that the budget, or at least the consideration of the fiscal framework, must be redone in Parliament. So the committee must act again, produce a new compliant report, and must go back to the House. The EFF asks for interim relief, suspending the adoption of the fiscal framework pending a challenge in Part B to the adoption of the fiscal framework. We submit that the problem with that approach is that it puts the whole budget process in limbo, because Parliament won't be able to go backwards and won't be able to go forwards until the EFF's Part B is decided. It won't be able to restart its consideration of the fiscal framework, and it won't be able to move on to the Division of Revenue Act. So it'll be stuck waiting for this court to act in Part B. That's why we say final relief is preferable, because it deals with the problem, Parliament knows what to do, start again.
It looks like the Commissioner, although he's not part of Part A, similar view on this.
Yes.
With regard to the views of
Yes.
that is in fact.
With regard to the fiscal framework?
Yeah, fiscal framework.
Yes. Yes. And when we submit that is the more appropriate course. It seems more drastic, but in this context, it's actually more respectful of Parliament, because it lets them get on with it, rather than holding them hostage until this court acts. but it's open to this court to grant either. Finally, on costs, Milady, we submit by what clearly applies to this case. So if we are successful against Parliament, we seek our costs. If we are successful against the Minister, we seek our costs, but I'm aware that in interim applications, sometimes costs stand over the party, so we would have no objection to costs and against the Minister, because that's interim relief, are costs in Part B. But both the Minister and Parliament ask for costs against us, if we're unsuccessful, because they say the Democratic Alliance is a political party here for political reasons, and therefore Firewatch doesn't apply. That's wrong. The case that says it's wrong is Democratic Alliance versus President of South Africa. The citation is 2014 4 SA 402 WCC. It's a decision of this court, paragraph 108, where Justice Rogers, exactly the same argument made. This was a challenge to e-tolling legislation. Exactly the same argument that the DA is politically motivated and therefore can't be protected by Firewatch. And what the court says is, one must regard to the character of the litigation itself. The present case raises genuine and substantive constitutional issues regarding the approach to tagging. The application is by no means frivolous or vexatious or manifestly inappropriate, and therefore Firewatch applies. Firewatch is expressly in paragraph 20, paragraph 16, that the motive is irrelevant. What matters is the character of the litigation. And so the fact that my client is a political party is irrelevant to applying Firewatch. Those are the questions. Thank you for the extra time.
Thank you, my lady. I start by acknowledging the fact that it's my first appearance before your ladyship in your new position.
Indeed.
Thank you, and just a word of congratulations.
Thank you.
I want to make 3 submissions in support of the relief sought by the EFF. We don't have the same problem that the DA has, because we have challenged both the decisions of the Standing Committee and the resolution of the National Assembly. So the difficulty that Parliament puts up, not that it is valid, but it doesn't apply to us. So the submissions we will make in support of the interim relief to suspend the operation of the committee decisions, as well as the adoption by the National Assembly, are the following. The first one is a narrow one relating to the VAT rate increase. We will submit that in addition to what Mr. Bishop has said, the VAT rate increase is substantively unconstitutional. And I will deal with the implications of Section 9 of the Constitution. The second part of that argument is, I will submit that the process through which the VAT increase was adopted is itself irrational and unconstitutional. In fact, it has elements of deception, because what they did, the minister and those who sponsored the increase, created the impression that it was subject to change. When you now read their affidavits, they say that they've always known that it was never subject to change from the 12th of March. So if you are a public representative and you go to Parliament and you tell your colleagues, don't worry, vote with me, this may change, you are deceiving them. And that is an improper use of public power. The third argument will be then to challenge the fiscal framework under Section 8.4 of the Money Bills Act. We have prepared a chronology, which I will refer to when I deal with the third part of the argument. Maybe I should hand this up. The third one. And hopefully that's enough. That will make things quicker. So let me then deal with the first argument why we submit that the VAT rate increase is substantively unconstitutional. The first is just to set the constitutional scheme for budgeting decisions, which we have attempted to set out in our heads of argument. From page 1311, paragraph 25 of the heads of argument. That's where it starts. And the first point we make is that the budgeting power is constrained by the Constitution. And all budgeting decisions are constrained by the Constitution. And the constitutional constraint is not only the principle of legality. Another constraint is the Bill of Rights itself. And we say the fact that the Bill of Rights has a constraining effect on budgeting decisions has two implications for us. The first is that when budgeting, there is a positive duty to achieve equality. And that is spelled out at paragraph 25.1 from the Battlestar decision. The second implication is that there is a negative duty not to take regressive measures, or sometimes they're called retrogressive, but the report calls them regressive. But those obligations apply when you are taking decisions such as budgeting. We say that there are that have had budgets that have been taken by our courts. And the courts have never shied away from making a ruling where the Bill of Rights is implicated simply because the word budget is mentioned. We've referred to those cases from paragraph 26.1, Rail Commuters Action Group versus Transnet, 26.2, the Blue Moonlight decision. In fact, Blue Moonlight was even more intrusive because the state argued in that case that it had not budgeted for something. It was not even budgeting, but doing it inappropriately. And the Constitutional Court said it is not good enough for the state to state that it has not budgeted for something if it should have indeed planned and budgeted for it in the fulfillment of its obligations. And so we say here in this case where the committee itself, because I will go through the report of the committee and I'll isolate the items, took the view that the VAT increase was a regressive measure. It also took the view that the VAT increase would exacerbate inequality and adversely impact the poor. And both Parliament and the Minister simply do not engage with those arguments. That Parliament says it's an irrelevant fact. But it's pleaded expressly in the founding affidavit of the EFF as a material fact.
Can I just ask Mr. Ngcukaitobi, doesn't this take us to the policy-making arena and
Yes.
the decisions that have to be made by other arms of the state and not the court?
Well, we submit that even if it does, even if you are crafting policy, which is the core function of the executive, it must still comply with the Bill of Rights. And you still have the obligations that are both negative and positive. And so it's not outside of judicial scrutiny. So we say that what the minister also simply does not engage with the arguments. What he does is to traverse trite territory about polycentricity, arguments that have been long rejected because it has long been accepted that the mere fact that a decision is polycentric does not mean that it is immune from judicial review. So we say that our courts have not viewed budgeting as a constitutional holy cow. And we set out all of the judgments that have budgetary implications that have been made from footnotes 20, 21, 22, and 23. So then, what are the facts in this case? What do the facts show? Firstly, the EFF alleged at page 07/34 from paragraph 110 of the founding affidavit expressly that the rights that will be impacted are the rights to substantive equality, particularly of the poor, that stand to be hit the hardest by the unlawful VAT hike. Section 9. Section 10, paragraph 1102. Section 25, paragraph 1103. Section 27, paragraph 11010 and 1105, section 29. But for my purposes, it's enough to stick to one right, which is the equality right. What the committee itself found, you will see at page 02/128, at paragraph 6.23.3. And this is the conclusion of the committee. I think Mr. Bishop said something about this being a recordal of submissions. No, it's actually a conclusion of the committee. That's how they assessed the evidence in front of them. They said, and you see this at 628, where they say the committee notes that the proposal to increase VAT by 0.5 percentage points in 2025 and 2026, which will take the VAT rate to 16%. The committee further notes the following, so that's their finding. 6.283, that increasing VAT would have a disproportionate effect, adverse effect on the lower and middle income households, exacerbate inequality and the cost of living due to its regressive nature. And later on at 6.286, they say the following, that most stakeholders, however, have strongly opposed the VAT increase, particularly in the context of the ongoing cost of living crisis. That's actually a gross understatement. What had happened is that there were 48 submissions. Only 2 supported the VAT increase. It was PEP and PricewaterhouseCoopers. Every other submission rejected it. So you have a scenario in which the public participation process, the VAT increase is opposed by more than 98%. In fact, it then becomes a farce. The whole participation process becomes totally farcical. So when they say most stakeholders, what should have been here is that about 98% said no. 6.287, they say the following. The committee therefore acknowledges that while the VAT increase contributes significantly to the revenue framework, it raises serious equity concerns and must be carefully monitored for its impact on low-income households. There is a need for ongoing assessments of mitigation measures and transparency regarding the revenue raised and how it supports inclusive expenditure priorities. Now you see that there was no such inclusion. They noted the problem, that there are equity concerns, that there should be mitigation measures, but there were no such mitigation measures.
Doesn't this issue not go to the question of ambiguity or the fact that the conclusion reached or the conclusion reflected on the report is not supported by the narration
Yes.
of the committee and what the committee actually debates and finds in its report?
No, look, my lady, if I may say, this is an excellent point. It addresses I had seen it as an equality point, but it's also a rationality point. And then the solution, if one recalls, that was proposed by the minister was to zero rate certain items. But that is expressly rejected by the committee at 6.30, where the committee says, the committee notes the National Treasury's position on zero rating is a blunt instrument, as poor households still pay VAT on non-zero rated products and services. The committee recommends that the National Treasury should consider the recommendations made by the stakeholders on the list of zero rated items, which include an establishment of an independent expert panel to evaluate. So they did not find that the zero rating is sufficient protection for the inequality problems that the increase would exacerbate. And then at 6.31, As the committee notes the decision to not adjust PIT brackets for inflation, generating 19.5 billion in additional revenue. And then look at what happens next. The committee is concerned about the impact on lower and middle income households and recommends that National Treasury assess the equity implications of the fiscal threat and explore alternative progressive tax measures. And at 6.33 on the same page, the committee recommends that National Treasury and SARS should reconsider these proposals and engage further with the stakeholders to assess the viability of selected alternatives, especially where proposals are supported by credible empirical evidence. So I've taken 6 parts of the report where the committee itself acknowledges expressly that the 0.5% will exacerbate inequality. And this is in a country which already on the Gini coefficient is the most unequal in the world. Now, none of these were actually considered, these concerns, when the decision was made. The mitigation measures that were mentioned were simply not brought into operation. So it's therefore clear on the facts that the 0.5% percentage increase is a regressive measure. It exacerbates inequality. It is therefore in breach of Section 9 of the Constitution. You would therefore expect to find a substantive justification in the answering papers. The problem is that the answering affidavit of Parliament avoids the topic altogether. In fact, it says this is not the issue before court. It's not clear how they could have come to a conclusion in the light of the EFF intervention that squarely raises the problem. And then you think, well, maybe the minister will give a substantive justification based on the equality concerns. But you also find that the minister does not, in fact, justify the 0.5% other than by saying we need additional revenue to cover a number of other government spending requirements.
Does it not say to ameliorate that we're going to increase the number of goods that are zero rated?
Yes, but that's already been rejected by the committee itself, because it said the zero rating is a blunt instrument because the poor still have to pay for the other goods that are not zero rated. And in any event, there is no zero rating right now because it is yet to happen through this independent panel that is yet to zero rate. So at the time the decision is made, there is no evidence of what is the impact of zero rating on the poor.
So by the 1st of May, there will be no zero rating to
Absolutely.
speak of.
There will be no change on zero rating, but the poor must pay percentage increase.
Well, in fact, there's no panel yet.
There's no panel at all. Yes. So that zero rating, as Parliament said, is a blunt instrument. It doesn't take us anywhere. So we have a scenario in which there is a clear violation of constitutional rights. The 2 organs of state that are responsible for budgeting have forgotten their constitutional obligations to the poor. And we don't have to succeed on a final basis. This is a case that depends on a prima facie right. So we say that is sufficient. And here it is not as if there are no alternatives. And again, they don't have to take the EFF alternative. The EFF says you must tax the rich. But you can ignore that and say that's political rhetoric. But what you cannot ignore is the Commissioner for SARS, who himself says there are alternatives. And those you will find at 02/121 under paragraph 5.2. And the last paragraph there, where SARS is making a presentation, and they say the presentation estimated South Africa's tax gap to be between 700. I am at 02/121.
Yes, I'm there. But
Yes, at the last paragraph under paragraph 5.2. Yes.
that's all it is.
Yes.
Yes.
Yes. So this is what SARS says as clear alternatives. The presentation estimated South Africa's tax gap to be between 700 and 800 billion annually, with only 58% of the theoretical tax liability being collected. So that's 42% uncollected tax on time. SARS identified key under-resourced areas, including illicit trade, syndicated tax crimes, aggressive tax planning by large businesses, international tax compliance, high net worth individuals, ports of entry, and debt recovery. So that's where they say the money will come from. SARS outlined immediate and medium-term plans to enhance compliance and revenue recovery. These include expanding the debt default recovery program, which is in a pilot phase, resolved over 600,000 cases and collected 25.2 billion in cash over 15 months at a cost of 300 million. SARS plans to increase full-time equivalents from 858 to 2,500, with the goal of collecting 20 to 50 billion annually. Additional strategic investments of 2 billion per year are required to support this effort. And then that goes on to the last paragraph in that page. So the point is that Parliament itself and the minister himself were told by the Commissioner of SARS that there are alternatives to the VAT increase. They were not told by my clients or the DA or anyone. They were told by their own commissioner.
I'm just going back to the policy choice question and the courts of how far can the court interfere in that arena, where SARS says and the minister says, well, these are the policy choices that we've made. We've looked at alternatives and we find that VAT is the best alternative in the circumstances. How far can the court say, well, we question that because we think that it will leave the poor worse off than this other one? Can the court say that?
Yes, if the Bill of Rights is implicated. The problem is that the Bill of Rights is actually a trump. So you have to make those. The law is not that the government can simply assert that we've made this policy choice. The law requires the government to account by reference to the standard in the Constitution about why they have made policy choices and why they have rejected certain alternatives which were made available to them. So there is no constitutional blank check simply because you use the phrase budgeting. And so that's just a narrow case. In circumstances where, one, it's clear that there will be an exacerbation of inequality, and two, it's clear that Parliament itself says there will be inequality, and it's clear that there are available alternatives. It's arbitrary then in those circumstances to suck your thumb and say, I'm sorry, I want to increase VAT. So what we are asking the courts to do is to be more exacting in the evaluation of the conduct by the minister. So we submit, therefore, that there is a strong substantive argument in favor of suspending the decision pending a review in Part B. And we say when we actually evaluate the answering affidavit, there are no direct answers. In fact, when you look at the answering affidavit of the minister, it starts at paragraph 68 in the EFF answer. It just never answers anything that comes before paragraph 68. Then I must move on to the second problem that we have, specifically just on VAT. The second problem is that what they seem to have done, the minister and those who promoted this vote in Parliament, is that they have simply said, look, this seems the Action SA fell for it. But it doesn't matter. Action SA were acting as members of Parliament, not as a separate political party. Was to say, look, don't worry about this. We can put in a condition that we will change this in due course. So vote for it. Now, there is a fundamental problem with adopting that approach. It may be politically convenient, but it's deceptive. And public power should not be used deceptively. Public power, the first and the primary duty is that you must be honest.
Now, the minister's decision has been directly attacked by the EFF.
No, we say that we don't have to, because our challenge is, because you remember that the deception did not come in the introduction on the 12th of March. It came on the 1st of April. So we say you've got to look at his conduct in totality. His conduct in totality reveals deception.
Yes, I understand that, but what I'm saying, the relief sought, there's no, if I recall, there's no order sought against the minister's decision to say you impugn this decision, this conduct, and therefore the decision must be set aside or must be reviewed or we must do something about it. So there is no direct challenge against the minister. Yes. That's what. the challenge is against the reports of Parliament.
Yes, no, your leadership is correct. What we submit there is this, that the Minister's decision under Section 7.4 is part and parcel of the budgeting. Unlike the DA, we don't accept that if the fiscal framework is set aside, there is a self-standing decision of the Minister that survived the setting aside of the fiscal framework. Our reading of Section 7.4 is that the two are inextricably connected, especially when you look at the text of the section, which says if an increase is contemplated as part and parcel of the budget under Section 27 of the PFMA, then the following must take place. We see that as meaning that because the increase is part and parcel of that budgeting and the fiscal framework, once the budgeting and the fiscal framework fall, so does the Minister's decision.
So once the resolutions from Parliament are set aside,
Yes.
then you're saying Section 7.4 cannot come into operation, or rather the announcement cannot become effective.
Again has said, it really becomes a problem when politicians act like this. Throughout, the Minister did not on the 1st of February say, I'm trying to increase VAT. He said on the 12th of March, I'm trying to introduce a budget that includes a VAT increase. That's what he said. Throughout, he always accepted that the two go hand in hand. The first time there was a theory of separation is when the hiring affidavit was filed. So even his own conduct showed that he understood the two to go together. So that's why it's not appropriate right now to try and separate the two. The two decisions are one and the same.
So the VAT increase is tethered to the annual budget.
Precisely.
And tethered to the annual budget, the resolution approving the fiscal framework.
Precisely, yes. And throughout the debate, the main issue that these parliamentarians debated was the VAT increase. When they were trying to adopt the budget and trying to pass the fiscal framework, they were debating the VAT increase.
But where's the deception?
No, that is not the deception. The deception is the idea that this is subject to change. When they knew that they had no intention of changing it, that was deceptive.
Ngcukaitobi, is that not politics?
Yes, but there is no problem with politics per se, but what we are concerned with here is the conduct of the members of Parliament in Parliament and the message they're sending to us as the voters. Now,
Mr. Ngcukaitobi, isn't it perhaps just a misunderstanding of the whole legal framework of the fiscal framework? How it interacts and how it fits into one another. Wasn't there perhaps a misunderstanding rather than a deception?
No, there could be there could be a misunderstanding, I accept that. But where the minister today, if one looks at his answering affidavit, that says that I never thought this was going to change from the day I announced it on the 12th of March.
So he knew beforehand.
He knew beforehand. So it can only be deception. In Parliament, the impression was created that these recommendations can be put and these recommendations can be altered. In fact, my Lord, I'm glad you raised that question because it's not me saying this. It's actually Mr. Oratile. You go to page 07/18.
Yes, I'm there.
Yes. So 07/18, paragraph 47 says Oratile, who is an MP and Action SA's national leader, is on record making this exact point in a media briefing he hosted on 2 April 2025, following the National Assembly and NCOP's adoption of the impugned report. In that briefing, he made the following statements. 47.1, as per its negotiations with the ANC, Action SA's support for the fiscal framework is conditional on the finance minister scrapping the VAT increase recorded in the annual budget and fiscal framework. 2, having expressed his irritation with his perception that the ANC is reneging from its appointment and misrepresenting the facts leading to the adoption of the impugned report, Oratile asserted that the ANC must implement Action SA's recommendations, which were the preconditions as stated. 3, pulling out his phone and reading his negotiation exchanges with the finance minister, he stated that the latter said to him, I imagine you will be able to come up with proposals to replace the revenue proposals. to which Action SA made its conditional support proposals. It was at this point that the poison tree blossomed and gave rise to the impugned report fruit. It is that sequence of events that gave rise to Beasley amendment proposal as agreed with the finance minister and the ANC. And then it goes further. 4. Trollip went on record that following that precondition and concession, Action SA then approached and convinced Bosa and Rise Mzansi to vote in favor of the impugned report adoption. He repeated the condition in another interview to which I will refer to in a moment. So, it is him who says the minister has misrepresented the truth. So I say that the minister is guilty of deception. So once you have a budgeting process that is so colored by deception, it is fundamentally in breach of the duties imposed on members of parliament, especially our National Executive Committee. So you cannot endorse a budgeting process where the deception is so clear. And in fact, you know, my lady and my lords, I've been reading from paragraph 47. If you actually go to the minister's answering affidavit, I just want to find it. The answering affidavit starts at 035. There's something that will shock you because the answer to the EFF is at 0351.
Zero.
0351.
Yes,
That's
okay.
where the answer to the EFF starts, the seriatim. And you see where it starts at paragraph 85. And at paragraph 47, which is where the accusations of misrepresentations are made, is just not answered.
Sorry, you want zeros?
0351, and I'm comparing with 0719.
Yes.
So if you go to 0351, where they start the seriatim response to the EFF at paragraph 101, they start with paragraph 85. So compare that with paragraph 47, where the accusation is made by Trollip that the minister is guilty of misrepresentation. That is a very, very serious accusation. You would have expected that it would be met frontally. It's just not unanswered. So
what must we make of that now?
well, it still comes back to whether or not a report that is undermined by deception and misrepresentation can pass the rationality standard. Because remember, the EFF challenges the report on substantive unconstitutionality and irrationality. One of the grounds for irrationality has been highlighted by the leadership presiding, which is there is a mismatch between the content and the outcome. But another one is that this is a report that is a product of deception. It's not honest what happened here.
So at the time the minister engaged Action SA, he knew that
Yes.
the VAT rate which he announced on the 12th of March cannot be
Yes.
changed.
That's what he says now in the answering affidavit. You know, he says, from the onset, I made my decision on the 12th, and that was it. So then that calls into question then what on earth was he doing with Trollip lying to him? So you will see this right at the beginning of the minister's answering affidavit. I'll find it now. Yes. So it starts at 03.12, paragraph 15, where he says, I exercised this statutory power on 12 March 2025. Then he explains. There is a specific paragraph that says that it's where they deal with the separation, where they say it's clear that these two are separable, and once announced, it cannot be changed. I will find that. If I don't find it before I finish my argument, I'll tell the court at a later stage. Yes. It's 0324, where he's talking about the implementation of the VAT decision. So paragraph 48, and then paragraph 50, where he said, that said, the decision as to whether to give permanent effect to the VAT rate adjustment now lies with Parliament. In due course, Parliament will consider a debate. 0324. So the first one is the very top of 0324, paragraph 47. In fact, 0323, paragraph 46, that's where it starts. Yes, I've now found it.
Yes.
Since its announcement, the decision has been widely communicated across the country, and businesses and consumers alike have relied on it in planning for the financial year ahead. Paragraph 47. The VAT rate is therefore set to increase to 15.5% on 1 May 2025. Then paragraph 50, at same page, that said, the decision as to whether to give permanent effect to the VAT rate adjustment now lies with Parliament. In due course, Parliament will consider and debate the proposed legislation, and to the extent it sees fit, pass or amend it in accordance with the procedures set out in the Money Bills Act. So it comes back to this point I'm asking rhetorically. What was he doing misrepresenting to Tony Trollip, which he has not answered in our founding affidavit, when he knew on the 12th of March that on the 1st of May, this increase comes into operation? What were they trying to achieve when they said there is 30 days from which you can come back and re-debate the issue? So I'm saying that deception is anti-constitutional.
But is it not so, Mr. Ngcukaitobi, that it ultimately was in the hands of Parliament?
Well, it is still, technically speaking, now in the hands of Parliament. But what I am suggesting is that even in Parliament, if a vote is procured through deception, it is still unlawful. You could say that it is a matter of politics. You've already said so, Justice Savage. But I'm not sure what that means.
I'm not a politician.
Yes, no, I'm not sure, Justice Savage, what that means, because there are several candidates about what that statement might mean. The one is that South Africans must accept that politicians will lie in the course of doing business. I don't have a problem with that. I have a problem with it when they're discharging constitutional functions. But if they're sitting in Lutuli House and lying to each other, there's no problem. But what we are dealing with here is a matter of immense national importance.
Do we not know that what was occurring was the ANC was needing support for its budget? So it was looking for supporters. It was looking for support from other political parties.
Yes.
So that was part of the process, was trying to secure them.
It is absolutely clear. That's what they were trying to do. The problem is
There's
that
nothing wrong with that, but they shouldn't deceive the public.
precisely because the contamination of deception is in the report itself. Because it's the report that says we're coming back in 30 days. So once the report is contaminated by that deception, then it is unlawful. It cannot be given legitimacy by the court.
I just want to understand, there's two players here. We're talking about deception by Parliament or the committee, and a deception by the minister.
Yes.
So the one you're dealing with is a deception by the committee.
Yes.
And is that, did the committee actually understand? Didn't they think that, well, the ministers must still come back to us? Is it a matter of deception, or is it a matter of maybe misunderstanding the legal framework or the 7-4 powers that the minister has?
Well, there are two candidates to this. Maybe the two of them are together. Certainly on the minister's side, who now claims that I've made my decision, it comes into effect on the 1st of May, a case of deception can be established. But when it comes to what were the parliamentarians doing when they included in the report that this matter will come back? Were they trying to deceive the public, or were they genuinely confused? If they were genuinely confused, it's still irrational.
I get your point.
Yes. Now, so we will submit, therefore, that on both of those two grounds, there is a substantive unconstitutionality problem and a deception stroke grave confusion. Both of those contaminate the VAT rate increase so significantly that it cannot be given a stamp of approval by this court. That takes me then to the last of the three. I wonder what's the time. Sorry, no, that's fine. That takes me to the last of the three, which is what actually happened in the committee. So the starting point here is section 8.4 of the Money Bill Amendment Procedure Act. So the section states the following. So section 8.1 starts by saying that the National Assembly and the National Council provinces must refer the fiscal framework and revenue proposals to their respective Committee on Finance. So there is a clear obligation that it must go to the Committee on Finance. Section 8.2, the committees must conduct joint public hearings on the fiscal framework and revenue proposals. Section 8.3, the committees must, within 16 days after the tabling of the national budget, submit a report to the National Assembly and the National Council of Provinces, as the case requires, on the fiscal framework and revenue proposals. And then section 8.4, the report must include a clear statement accepting or amending the fiscal framework and revenue proposals. So there seems to be three distinct duties. The first is a National Assembly duty to refer the fiscal framework and the budget to their committee. The second duty is, once it is in the committee, there is a duty to conduct joint public hearings, both on the fiscal framework and the revenue proposals. Then it must be tabled to the NCOP, but when it is tabled, that report must include a clear statement accepting or amending the fiscal framework and revenue proposals. The EFF's case on this score is twofold. The one is to criticize the process of deliberation that took place at the committee itself, that process of deliberation was farcical. Now, if your ladyship and my lord go through the document I handed up, you will see a comparison. I think it's the 8th page. You will see a comparison drawn from the pleadings of what we say happened at the committee. And there are 10 items that have been isolated there. And what the speaker says and what the minister says. And so we've classified this in the heads of argument as absence of deliberation. And we've cited various constitutional judgments that show that the heart of Parliament is a deliberative assembly. So there has to be a meaningful engagement and a meaningful participation with the substance of what is presented before them. So the first one is that the criticism is that there was a request to the speaker by the EFF.
Paragraph?
Paragraph? Well, it's the first paragraph, paragraph 12 FA. These are not numbered, but they are in table format.
Okay.
Yes. So
this is the letter that was sent to try and stop the vote.
To try and stop the vote, yes. Which is admitted, but the minister says nothing about those. But the point here that is made is simply this. These are not, the irregularities were brought to the attention of Parliament. It is not as if Parliament was unaware of the irregularities at the committee level. They were brought to its attention. So it approached this task with its eyes open about the problems. So it therefore accepts it. I know that the Speaker of Parliament responded to the DA and said that her advice is that there were no irregularities. That's all fine. But the point here is that if there were irregularities, these were brought to the attention of the Speaker prior to the vote. And so when they voted, their vote was to endorse those irregularities, which is not allowed by the Constitution. Then the second allegation that is made is this, and I think it was debated when Mr. Bishop was arguing, which is, however, this conclusion and the insertion in the impugned report, that's the insertion of the word accept, was done post the sitting of the Finance Committee and was not in fact deliberated upon and concluded by the Finance Committee, despite Sinawo Tambo, who's from the EFF, having proposed at the beginning of and halfway through the sitting that the Finance Committee starts off by taking a position on whether it accepts or wishes to amend the fiscal framework, which would in turn inform the report it was seized with, not the other way around. Now look at what the answering of the Parliament in the next column. It is correct that the insertion was made post the sitting of the committee. I refer to what I have stated and maintain that it reflects an accurate account and statement of what occurred at the meeting. The remaining allegations are denied. Now that allegation is very important because she never identifies where the item that is being voted on, accept or amend, is ever presented to the committee during the deliberation to vote on. Never identifies that.
It's common cause, it was not there.
It was not there. Yes. But what is concerning is the bold denial by the Speaker, who is herself a repository of public power, where she admits that the insertion came afterwards. And then there is a third, and again, this is not a technical fight. It's a fundamental element of Section 8.4 based on the rule of law. They have been given a power, and the Parliament has decided this is how the power is to be exercised. But they themselves, as lawmakers, are just deciding to ignore it. And then,
But Mr. Ngcukaitobi, in that regard, it's also common cause that on the same day of the report, the 1st of April, both the EFF and the DA, their representatives from the committee email the secretary of the committee and say that's not what was agreed in the committee.
indeed,
And this report does not accurately reflect the situation.
yes, indeed.
And the following day, in spite of that, and in spite of their letters to the Speaker, both by the DA and the EFF, to say don't go ahead with the vote.
Yes.
It's rushed through and the vote's not.
Yes, they rammed through. They thought we've got this gap now because Action SA is with us. Let's put it through.
Arguably, there would be a basis in which to say that an issue could be discussed by a committee, and the report could be a correct reflection of that report after the fact could then be sent to Parliament. In certain circumstances, fact dependent, that might be acceptable. But in this case, the facts show completely the opposite.
Yes, the facts show that the report was a distortion of what had happened. And that distortion was brought to the attention of the Speaker. The Speaker nevertheless ignored it.
What is to be made of the word approved in the minute?
Whatever that word means, even if it means accept, it is still undermined by the condition, which is also included in the report. Because the section says clear statement, and once you put the condition, it takes away the clarity. So it's the main argument, by the way, by the Speaker, is to say sometimes they use approve, sometimes they use adopt. But they always shy away from accept, which is the language in Section 8.4, because they know that accept is not conditional, even in contract. If you say, I accept, but that's not an acceptance. So the third irregularity is then identified in the following section, which again is, objections being raised. And when you look at the answering affidavit, that's not being addressed directly. And there is a fourth one. There is a fifth one. 10. The sixth one, again, no answers. A seventh irregularity, an eighth irregularity, and what you say is the content hereof is denied, the content hereof is denied, a ninth irregularity, and a 10th irregularity. So we've taken the time to go through this quite carefully, and we've come up with 10 irregularities that simply cannot be answered. So I'm afraid what you have, what the court has, is that it has a report that is so fundamentally undermined by the irregular way in which Parliament conducted itself, which is in conflict with Section 8.4, and therefore cannot be given effect. What that really leaves is, well, can you do the separation? We've showed in our heads of argument that you can't come and rely on a different section after the event. If the minister's case was always, I'm increasing VAT, I don't care about the budget, and I don't care about the fiscal framework. That was never his case. That case came in the answering affidavit. So therefore, he was always trying to increase VAT as part and parcel of the budget and the fiscal framework. So he's bound by that election. Then, well, what is the court supposed to do? Well, we submit that it's inevitable that relief must be given to the EFF and the DA. The question is whether interim relief on the fiscal framework or final relief. We've asked for interim relief. Mr. Bishop, as I understand him, says that interim relief might not be appropriate because it would sterilize parliamentary processes until Part B is had. It's unclear to us why it would, because if the current process is interdicted, it's clear that they may not proceed with it. But that doesn't mean they may not start a new lawful process.
Can I just ask paragraphs 3 and 4 of the relief, which suspend the report of the Standing Committee and then the reports of Parliament after that? Has the boat not sailed in respect of that report? What would the suspension of the report do? Because that has already been, that's gone through the process and voted on. And so what would the suspension of the report of the Standing Committee do at this stage?
Well, my lady, we do ask in paragraph 4 for the suspension of the National Assembly resolutions. What we were worried about is that a court might say that there was nothing wrong in the National Assembly resolutions, and therefore we had to attack both of them. But again, if you only gave us paragraph 4, theoretically, you still have the problem that you've got the poisoned report of the Standing Committee, which still remains and has not been suspended.
I think my question goes to, is it not the setting aside that should be granted rather than a suspension? Because a suspension, what does it really do?
Yes, it may not be just and equitable. But let me just say this. The relief that should be given is just and equitable under Section 172, and that's what Godan says. And also says that you are not bound by my formulation of the remedy. What you must give is what is just and equitable.
So if it was final relief, you would be covered.
Yes, that would be given. But I submit that I do meet the threshold for final relief. But, we had asked for interim relief, but the fact is that the facts are so clear and the law is so clear that the court would be entitled to give final relief in its discretion. If the court gives final relief to the DA, then my arguments are only supplementary to the DA. I don't need separate final relief.
If for instance, we give final relief to the DA, and then paragraph 5, which is the interdict, would still stand. Is that right? Is that what you're saying?
Yes.
So in respect of 3 and 4,
yes,
we can actually give the final relief in respect of that, but paragraph 5 still stands because that's the interdict pending Part B.
Yes, indeed, because there is Part B even on the DA's formulation of the case. But I still need Part B anyway because I need to finally set aside the VAT increase.
Okay, okay. So Part B in this instance would only be in relation to the VAT increase and not the report, because the reports would have been catered for in the final relief.
If you gave the DA final relief, then I don't need any final relief. My arguments will simply support what the DA has said.
Okay.
But it's in that event that you think final relief is inappropriate, that I say my paragraph 3 and 4 are appropriate.
Okay.
I have nothing else to add. Well, we're entitled, there are 4 of us. We should be entitled to cost of 2 counsel. The case is sufficiently complex. We are immunized from cost by BioWatch.
Yes.
Thank you, Mr. Ngcukaitobi. Can we perhaps break early, now at 1:45, come back at 1:45? We'll make arrangements that you come in. You're allowed to come in at 1:45. All right, quarter gents until 1:45.